Hey folks, it's attorney Roger P. Foley, and I have not been on for a while. Took a little bit of a vacation, which was nice, and now I'm back in the office. Today was the first day, and today I primarily just worked on some housekeeping matters, some hearings coming up, and some case law research. And just figured I would check in and say hello. One of the matters that I was researching, and it's a common aspect in Florida, is when do the police need to, or when do you need to identify when speaking to the police in Florida? And people ask these questions, they throw out the answers like it's a perfectly sculpted answer, like it's black and white, but it's not always black and white. So I have a case where police approach my client, is walking in the evening time, and as he walks past the vehicle, he looks inside it, doesn't check, doesn't do anything. Police stop him. Actually, one of the officers pulls their weapon on him and goes, "What are you doing?" He's like, "I'm just walking and looking, And they grab him and tackle him to the ground, and they charge him with loitering and prowling and resisting an officer without violence. So the question becomes is, well, what do you have to deal with when you're dealing with loitering and prowling? And one of the case law suggests, as well as the statute, is there's really two elements to loitering and prowling. The first element is that you have to be in a place, and I'm not giving you the exact words here, folks, so don't hold me to the exact statute. I didn't memorize it. But you have to be acting in a time, place, or manner that is not consistent with a law-abiding citizen. So when you take my facts of walking down the street in a residential neighborhood, it's legal to walk down the street in a residential neighborhood. Well, what if it's 6 a.m.? Is that okay? Do some people get up early, or is that a crime? Well, what if it's 10 a.m.? What if it's 2 p.m.? What if it's 10 p.m.? Does it matter, right? And the reason I point that out is because police, the courts, they always talk about the totality of circumstances, right? So with someone, right, I'm driving home right now, and it's 5:14. And if I see someone walking down the street at 5:14 on the sidewalk, is that abnormal, right? So, and then the second element, make sure my brain's on right because I got a sinus infection. But the second element is that they have to be, how do I word this? I didn't write it down, and I don't know exactly how the statute words it. The first part is place or manner, and then the second one is that sort of like they are almost about to commit the crime but haven't quite committed it, right? If that makes sense. So for instance, if I guess one of the main cases, right, is was it cats? No, not cats. Hang on a second. Too much going on. Oh wow, I'm having a blank. Anyway, I can tell you the facts of the case. I just can't tell you the name of the case right now. I'll think about it in a second. It'll pop into my mind. So, and the leading case on whether, Terry stop, sorry. Terry v. Ohio. Took a second. So, in Terry v. Ohio, the officer, a beat cop, is watching, standing on the road. He's walking his beat. And he sees a guy talking to another guy, and they're looking in a store, and then they one guy walks away, then he looks down the alleyway, kind of looks suspicious, and then he walks away, and then the other guy walks to the alleyway, and then this guy looks back into the window of the store. Well, that could be innocent, or it could be more. Well, these guys continue to do it. Now you end up with 3 different guys, right, in Terry v. Ohio, and they look in the window, then one walks away, then they separate, then the other one looks in the other alleyway, and the officer starts to think that, hey, they didn't just do it once or twice, right? Like they're waiting for a friend, or waiting for the store to close, or like waiting for someone outside, like a fellow employee. Now it looks like, hey, I think these guys are casing the joint. I think they're about to rob the place. Now, he's got a thought, right? Doesn't mean that it's right. So he watches these 2 guys, and the third guy comes into play, and they literally look in this window and in the alleyway 20 plus times, right? So the officer's like, something's going on. So he gets close to them, and he thinks he sees something, and he reaches and grabs, and the guy had a firearm on him, right? Now, in that case, they said, well, you have to weigh, right? You have to weigh someone's right to be unseized, right? The 4th Amendment, you have to weigh that versus the risk, the imminent risk to society. So going back to loitering and prowling, acting in, outside the normal course of how people act, and the second part of that prong that I was kind of blanking on before is whether or not a person or property is in imminent danger, right? That the person who's doing whatever act they're doing, whether that person sort of made a conscious thought like, hey, if other people saw me, they would think there's an imminent risk of harm. So in loitering and prowling, you have to have those 2 elements, right? They're doing something that's outside of the norm. I don't know, maybe they're, I don't know, whatever it may be. I can't think of an example right now. But I can tell you there's a lot of cases on the topic. So there's a case where some teenagers are at the mall, and they walk over, and the mall is closed, or it's kind of like, just think of like Palm Beach Lakes Mall. The door's closed, and they go over and slide, and they look in, and then they walk to the next one. And the court said that, it is not unreasonable. That if what the officer observes, right? If what the officer observes is ambiguous, meaning a crime could be being committed or not being committed, like it could just be normal, natural, conduct, that it could be a crime, it could not be a crime, then they need more to go hands-on. So mere suspicion, I guess the best way of saying it in a catch-all phrase is, mere suspicion of a crime is not sufficient to justify a Terry stop, where a detention and a pat down. So in one of the cases I'm working on, the officers see my client walking down the street, looks into a vehicle, and they automatically think, what's going on? And they rush towards him. What are you doing? And he's like, nothing, just looking at what you guys are doing. And they tackle him to the ground and ultimately charge him. So I think it's important, when I was first starting to look for a case, I was like, when do you have to identify in Florida, right? So if you are arrested, folks, and this is an important thing to know. Look how people drive. It's crazy, man. They just try to cut it, weave in, weave out. I wish I got to get the camera that you can see the road too. Guy weaved in front of me to weave behind. It's just crazy. Anyway, when you are arrested, right? Once the officer has arrested you, you must identify. You must. And if you give a false name, right? Because the Supreme Court, and I don't know what case it was, said that like basic booking questions like height, weight, address, Those are basic things. They're not inquisitive. Miranda doesn't kick in for those things. And your name to put on a form, right? That's not secret information. So if you are arrested, you have to identify. So now the question becomes, what if a police officer walks up to you, I don't know, you're walking at the courthouse or an airport or the grocery store, and a police officer walks over to you and goes, excuse me, sir, ma'am, what's your name? Well, that's what's referred to, and you probably heard this, a consensual encounter. It's no different than when a young man is in college and he walks over to a girl walking down the hallway in college and says, hey, my name is Bill, what's yours? We're in the same class together, right? She can say, oh, hi, Bill, my name is Sue and nice to meet you. Or she can go, I'm not interested in talking to you, Bill, and walk the other way, right? So now the question is, what about in a detention? In a detention, is it necessary, right? The officer, let's say the officer has some reasonable suspicion to detain you. So, let's then try to think of a reason that they would detain you. And there's even been cases where, let me backtrack so I can explain this thought better. There's been cases where someone calls the police and says, hey, there's a guy who has a gun in his pants and he's showing it to his friends. And the cop goes, well, who is that, right? And they point him out, goes, look, but I don't want to be involved, and they walk off, right? So the court says, well, the cop doesn't know if that's an illegal gun or if he's got a concealed weapons permit, right? If he has a concealed weapons permit, then he's allowed to carry a firearm on his person. And I know the law changed, but just go with the flow. Now, even if you don't have it concealed, you can do that. So just having a firearm and someone noticing it isn't reason for an officer to come over, because he doesn't have, remember, it could be innocent behavior or it could be criminal behavior. If it's ambiguous, he doesn't have a right to stop you. Now, in another case, and I don't know the names of the cases, I just know the stories, right? In another case, I write them down when I go to court because I'm never going to remember all the names. In another case, there is a person that says, hey, there's a guy waving a gun, right? Like he's got the gun, and my other hand's on the wheel and it's automatic drive, just so you guys know, all right? But in that case, the court says, well, listen, flashing or displaying a firearm, right, is illegal. It's a misdemeanor. So therefore, the officer can go over there and do a Terry stop, a detention, and a pat down. Because, why? Because the tipster, right, the person who informed him of it, explained that a crime was being committed. So if there's a crime being committed, like if you say, hey, there's a guy beating the crap out of a person, on the side of I-95, well, the cops are probably going to pull over and detain them and find out what's going on. And that's probably okay. But there's certain situations where it's not okay. And the law is a living, breathing mechanism. So you're dealing with situations where people just go, oh, I just know the answer. But you don't, because you got to, like, I literally searched for days, weeks, trying to find a case that says exactly, you don't have to identify to a cop. It doesn't say it. You find little pieces in each case that explain it. If you've been arrested, yes. So now the question is, if you've been detained legally. So now if you've been detained legally, do you need to give your ID? And I kind of think that that's a little bit of a question in the law. And if there's an attorney that's watching this and knows better and knows an exact case, I'd love to hear it. It seems to me, if they're legally detaining you, not illegally, but legally detaining you, then you have to give your name, right? If they're not legally detaining you, right, like that their reasonable suspicion for stopping you was not sufficient, then you don't. So as a citizen, how do you want to deal with that? Do you know when you're on the side of the road, like, I don't need to give my name? Well, maybe you do, maybe you don't. I mean, the attorneys are going to figure that out, right? The prosecutor and the defense attorney and the judge, they're going to do it. But I'm going to tell you, it's not a simple thing, because there's elements or prongs to each statute and each circumstances. And they always like to get that catch-all phrase of totality of the circumstances. So let's say I'm going to give you a crazy example. I'm going to kind of make it up on the fly, right? If there is a person walking down the street on, I don't know, what's the hottest part of the year in Florida? July, June, I don't know, probably the middle of June, right? June, July. So they're walking down the street and they are wearing a Santa outfit. Right, I'm just going to add some crazy, facts. Right, they're wearing a Santa outfit, and someone says this is weird, and they're holding a bag, and it looks like a big Christmas bag, like you would put gifts in, and they're walking through a parking lot at the mall, right, and they're looking inside vehicles. Now, looking inside vehicles, right, when I'm driving past a Jeep right now, I can look inside the vehicle. Kind of normal, right? They're looking in the vehicle, and someone goes, oh, I could see some kind of bulge, and they call the police. Well, now the police need to independently verify, right? Because let's say it's an anonymous tip, which has less value, right, according to the courts. So the officer comes and he sees a guy, and it's 105 degrees out in Miami. He's walking through I don't know, what's the one over there, and what's the mall down there past I can't remember the name of it. He's walking in a Santa suit. He's got a bag. He looks a little disheveled. He's carrying a big bag, and he's looking at cars. Now, you might think, well, can a cop stop him? I don't know. I don't. My first inclination is I can dress however I want, right? Is my manner of dress, right? In Trayvon Martin, what did we discover? Like, is a hoodie, an indication of crime, right? You're wearing a hoodie, whether it's, my father-in-law wears a hoodie and like a bomber jacket in the middle of summer and lives with us, right? So, and my mother-in-law wears, like practically a fur coat. Everyone's body is different, and even if they're older, but I mean, so that's the first thing. Is that unusual? That's a little unusual, but it's ambiguous, right? So what about the bag? Okay, well, I mean, Santa would normally carry a bag, right? If he didn't have a bag, that would look weird too, right? So you can kind of play with that in a jovial manner. But now you're walking around Walmart and you're hanging out for like an hour, and several people call in and go, hey, there's some guy just looking in cars. He's dressed up like Santa. And the cop sees him. Now, could the cop do a consensual encounter? I think he can. I think a cop can always do a consensual encounter. Sir, how you doing? What's going on today? And just like when Billy introduces himself to his college co-ed and wants to get her number to supposedly study, she can say, or he can say, hey, my name is Santa, or he can say, screw off, police, or he could be more vocal and more arrogant or rude. It's his First Amendment right. So then what can the officers do? Well, now if the officer grabs him, do they have reasonable suspicion? Is it illegal detention? And I would say no. Well, now let's change those facts. Let's say that Santa walking through the Walmart parking lot is grabbing on multiple handles of different cars, right? Or let's do one. Let's say he does one car. He grabs the handle and shakes it, and then walks away from it, acts like he's walking back into Walmart. Is that sufficient? Or could his wife Helen or Miss Claus, be inside Walmart? Well, one, you can make an argument that there's nothing, it could be ambiguous. If he's going to multiple cars and doing it, what if he's entering and exiting multiple cars? Well, now I think you start to see like someone who's burglarizing cars and they're in the process of it. And of course, a police officer can stop. But each one of these details, right, and every case is fact specific, allows you to realize whether or not police can identify, whether you're required to identify, or whether their detention is legit. So I'm researching these issues based on several cases that I have. And you think, hey, I've been doing this for many years, but I don't way of sort of explaining what a criminal defense attorney does when their client is stopped by police. Okay, now you can take that same fact pattern, and it seems like a lot more common with vehicles, right? But a Terry stop, what we're talking about, is supposed to be meant for the safety of the officer, because the Supreme Court, right, has said that a simple pat down over clothing, right? I'm sitting in a traffic light, right? All right, over clothing to see if there's a weapon, a knife, right? Something that could harm the officer is really such a minimal inconvenience that it's not sufficient to violate your Fourth Amendment right to be free from searches and seizures. They're not going in your pockets. They're not pulling out, right? They're not showing rabbit ears, right? They're not going into your... Only thing they're doing is checking for a weapon, right? Because a weapon has some substance to it. And if they feel that, then they can take it for officer safety. But you got to get to the first part of it, like especially in these loitering and prowling cases. You got to be doing something in a manner that's like highly unusual, that can't be something that's deemed ambiguous. And then you have to be doing something that the officer can articulate, right? Reasonable, articulable suspicion. You always hear everyone on YouTube talk about, right? So that is something where there's an imminent danger to a person or persons or property. So, and then once they get to that fact, right, that second element, then the officer can grab. So, I'm driving down Indiantown Road right now. If there's a guy walking past, there's a truck for sale on the side of the road, and he walks over and looks into it and checks the door handle, and there's a big for sale sign on it. I don't know, does the officer have reasonable suspicion? He's walking down the street, he's not driving, he's not calling the number, but I don't think so. But I can tell you that there's a few officers around that probably think that they have reasonable suspicion. And I say this because loitering and prowling, and the court really talks about this in a lot of the cases, is that police often want to use loitering and prowling as a catch-all, right? As to say, oh, man, they were doing something that was unusual, like, oh, it's a high crime neighborhood, like he didn't want to identify. Like, he doesn't have to identify if he's not committing a crime. Or you can't articulate a high likelihood that he was just about to commit the crime. So what you find is a lot of cases, right, that involve loitering and prowling in the state of Florida. You will see more cases dismissed on loitering and prowling because the two elements that I'm talking about are not met, and then the officer grabs them and they find, there's one case where, the guy's like walking down the street at like 4 o'clock in the morning, and, he's disheveled and he's like singing, and the cop says, oh, well, there's a lot of burglaries in the thing, and, in the neighborhood recently, it's a high crime area, and the defense attorney goes, well, did anyone call the police today? Did anyone say that their car was broken into? Was anyone's house broken into? Were there any calls for a suspicious person? No. So then, like, hey, a guy's allowed to walk down the street at 4:30 in the morning if a guy wants to walk down the street. In that case, they found, I don't know, a whole bunch of drugs on the guy. he got charged with drug trafficking. And what happened? The attorney filed a motion to suppress, and because the initial contact, right, the illegal arrest, he didn't meet both of the two elements, there wasn't, right, there wasn't probable cause to arrest, and all the fruits of the poisonous tree, like the drugs that they found on him, and then the gun, right, all of that got thrown out. Now, did the officer have a good gut instinct? Yeah, but having a good gut instinct is not sufficient, and the courts have said it many times over. So, it's important to learn these things. And it's weird. I heard that at one of the law schools here at Nova, I think they teach like a street law to law students. I'm curious about how that class is, but it's like they teach street law. So I'm assuming that that's kind of things like that, when you need to answer questions to a police officer, when you don't, or, what your rights are specifically. I'm assuming it's something to that effect, but I don't know. There was a video many years ago that kind of even got me on the whole YouTube thing, where there were some attorneys giving situations like, when you're pulled over by police and putting your hands on the wheel and you're rolling down your window just a little bit and saying, sir, can I help you? Yes, a license, registration, insurance. I have my seatbelt on. Can I take it off? Can I get my wallet? Handing them the items, being respectful, and then, ways not to act, ways not to increase your likelihood of being arrested. Or there's a party at your house and the police just walk in. Well, they're not allowed to just walk in unless there's some exigent circumstance, someone's life is in danger. So if you're having a house party, young people, right? And I was a smart guy. When I was in college, every time I threw a house party, and we threw a bunch of them, I would hire the police. So the first time they came in uniform, after that, like everyone in the Birmingham Police Department was, hey man, that's a good gig, because they would meet college co-eds. Usually the young cops would come, they would have their radio, and they'd be like, hey Raj, get the DJ to turn it down a little bit. So, and then, they would call in, yeah, dispatch, we got it, it's covered, noises are reasonable, So, but if you don't have the resources to hire a police officer to hang out at your party, then you do not want to open the door. And if you do open the door, you want to open the door and close it behind you. And it doesn't matter what the officer says to you, because you're limited. I'm just leaving, officer, and you can leave or whatever, but you do not need to let him in. And he has a job to investigate. And what is it, a noise ordinance? Like woohoo, right? Write the noise ordinance. You can leave it in the mailbox. But anyway, I haven't had a case like that in quite some time. But I did have a case like that where the officers just walked in, and I think there was some underage drinking. Like there's some guys and girls like 19, 20 years old, and I don't know, they had like hunch punch or something. And that was several years ago, and filed a motion like, no one let that guy in. He's not allowed to just walk into a house. There's no exigent circumstance. So, filed a motion to suppress, and it was the person, I think they were charged with, the homeowner got charged with their children's friends drinking, which they didn't even know about, but they got charged with that, and were able to get it dismissed on the technical argument. So anyway, that's a little bit what kind of goes into a motion to suppress. Again, I'm talking about loitering and prowling this week because I'm working on some cases in regards to that. I actually have several cases right now where the officers use that standard, saying, hey, they were loitering and prowling. It's just a throwout. Oh, it gives them a reason to go hands-on, and it's really not, and the courts talk about it. But you never know your judge. You never know how well someone's going to appear and what other factors they're going to throw out on the stand, meaning the officer. So you got to do your due diligence and treat misdemeanor just like it's a life felony, and do everything you can to help your clients. So anyway, I'm attorney Roger P. Foley. I'm almost home, and I'm going to call it a night. I'll do some more videos soon, and hope you guys listen and enjoy, and we'll talk soon. See ya.